So, hello everybody. I'm happy to extend a warm welcome to all of you. You are attending now our webinar, Business Digitalization, and is a co-hosted webinar by Mattos, Filho, the Brazilian law firm, and by Noerr, German-European law firm. And I'm very happy to present my co-moderator. The co-moderator of this webinar is Amadeu Ribeiro. He is a partner of the firm's technology, innovation and digital business practice in New York. And Peter Bräutigam, I'm a partner in our business, digital business group, and I'm the co-moderator. And now I'm very proud to also present the speakers of today. The speakers of today, and ladies first, is Lisa Worcman from the Brazilian law firm Mattos Filho again. She is also partner in the technology, innovation and digital business practice of Mattos Filho in Sao Paulo. And also Paulo Brancher is also with Mattos Filho, and he's also a partner in the technology, innovation and digital business practice. And then I'm introducing my colleagues here from Noerr, and that is on the one hand side Jan Dinter. And so Jan is in our Dresden office, and he is in our digital business group. And I'm also presenting Stefan, Bauer, from our Munich office here at Noerr, and he is in the competition and antitrust group of our law firm, and he will then focus on those issues.
Thank you, Peter, and good morning, good afternoon, everyone. We'll start with a question to Jan, and the question, Jan, is from a legal standpoint, what is required to open an online shop in Germany, Europe today?
It's very easy to open an online shop or an online platform in Germany and Europe today. Basically, there are no special permits required unless you are in a highly regulated area such as pharmaceuticals. Apart from that, in an ordinary online business, you need to cover three things. First, you need an imprint, tell your customers who you are. That is very easy. Second thing is you should draft terms and conditions. This is not required by legal mandate, but it's highly recommended because the German and European regulations on e-commerce are very friendly to the consumer, and you have some ways to curtail some options for consumers to have a sustainable business. For example, when selling to consumers, you need to take into account that they have a 14-day right of return. And while you can limit that in some extent in your terms and conditions, you also have to be careful that you have the right wording and do not extend this right of return from consumers to businesses. So the third thing you need to do is you need a data protection statement. As soon as you handle personal data, you need a statement which sets out which data is collected and what are the purposes you use the data for. So basically, to sum it up, it's very easy. There's basically no license requirement, and you only need an imprint. We highly recommend you to use terms and conditions, and you need a data protection statement. That's basically it, and you can start.
So thank you very much, Jan. Yeah, let's before we go across over the ocean to South America again, I want just to highlight that you are all allowed, and we will encourage you to use the chat function to raise questions whenever you have one, and please feel free to do that anytime you want, so we will try to pick up all your questions then. Thank you very much. So now coming over the ocean to South America, and now to Lisa, to Brazil. Now, what are the main legal issues in structuring an online marketplace in Brazil?
Perfect. Thank you, Peter. So, as we can see from a Brazilian standpoint, things might not be so easy, but what we do have as main legal issues regard basically platform liability. So here, basically defective products, delivery of failure, false or abusive advertisement, user published reviews or comments, fraud. And so these are issues relating to platform liability that we should keep in mind when we talk about Brazilian legal aspects. Also, with regard to data protection, similar to the GDPR and actually inspired in the GDPR, we have the LGPD, which is our local data protection law, and basically it regulates the use of personal data and sets limits for data sharing. So that is basically our guideline here. And with regard to competition law, I think the main legal issues are the use of sensitive information by the platform and the adoption of potentially discriminatory conducts. So these are basically two legal issues that we should keep in mind. With regard to payments and considering that several platforms actually have payment structures within them, then the intermediation of financial flows is also regulated in Brazil and should be observed. And we also have tax potential legal issues because there's a recurring discussion regarding the tax bases and tax responsibility for intermediaries and marketplaces and platforms. So basically, these are the main highlights regarding the legal aspects that we should keep in mind in Brazil.
Thanks, Lisa. Now, I wanted to go back to Europe, and I had a question for Stefan. We know there are some changes underway on the regulatory front in Europe and the approach taken by the European Commission toward platforms. Can you speak to that, please?
Yes, sure. Well, there are actually a lot of discussions at the moment regarding platform regulation on the EU level. Well, the first results of these discussions were actually can already be seen in the adoption of the platform to business regulation, which was adopted in June 2019, but which provisions will only be effective as of 12th July 2020, which means as of next month. This platform to business regulation is applicable in particular to online intermediary services, which means basically business to consumer platforms, and in some of its aspects also to online search engines. The regulation itself covers only a few material provisions regarding in particular what and how to structure, what to write into your terms and conditions and how to structure your terms and conditions in some way, but it focuses more on the aspect of transparency. So there are several provisions for online intermediary services, i.e. the B2C platforms or search engines, where they have to be more transparent. This refers in particular to ranking criteria used by the platforms, to access to data by the platform, or to the use of MFN clauses, or also if the platform differentiates between different business users, or if the platform actually is self-preferencing. So it's preferencing its own services or products over the services or products of its business users. It's actually it's not clear from the regulation itself how the provisions of this regulation shall be enforced. Only the material provisions regarding the terms and conditions, there's a provision which states any provisions in terms and conditions which would be contrary to the provisions in the platform to business regulation would be void. Apart from that, enforcement is left to the member states. So this is what already happened, but as you said, discussions are still ongoing. Actually, only 2 weeks ago, the European Commission published an assessment paper, an impact assessment paper regarding policy options the European Commission would like to see in the future. And I only comment on the two most relevant, which would be adaptation and a reform of the platform to business regulation, possibly including more prescriptive rules in those aspects where at the moment there are only or currently only transparency obligations. And the second policy option would be a more flexible ex-ante regulation framework explicitly targeting large online platforms which are acting as gatekeepers. And the Commission considers either to introduce a list of blacklisted practices or the possibility to adopt tailor-made remedies on a case-by-case basis. So this is still rather new. It's still in the process. If you want to contribute to the legislation process, then you can comment until 8th of September. There's a public consultation from the European Commission regarding those new powers the Commission would like to have.
Thank you, Stefan, for the view on especially on the EC framework here. And now I'm very interested now in the Brazilian approach. So, Paulo, what is the regulatory framework in Brazil? For instance, as a question to that, are marketplaces for B2B or B2C regulated in the same way?
Well, thanks, Peter. And I think that I can get back to Jan's introduction in this particular matter. The idea of opening an online platform to sell products and services in Brazil are unregulated in the sense that you need to take care with the kind of product or services offered, but it's completely open for parties for companies to enter in that field. Now, one thing when we talk about transnational transactions and situations where a company, for example, based abroad wants to sell products or services in Brazil through a digital platform, one thing that is important to consider in Brazil is that it's not the fact that you are selling to a product or service to a legal entity that this would be naturally a B2B kind of transaction. And if you are selling to an individual, that would be a B2C transaction. It's not the way it works in Brazil. The idea of having a B2C transaction is addressed in the sense that if that product or service is acquired for a final use, then it would be considered a B2C transaction, but it's something that it's going to be included in the supply chain or being used for in the productive process of that company, then okay, that would be considered a B2B kind of relationship. And that's an important difference. Because if you were, for example, selling machines to companies, to legal entities or other products or services, but if there is a situation where it's a B2C kind of relationship, then we have the Consumer Defense Code that is applicable, and it addresses a lot of important aspects to consider, in the sense that it's a matter of public order in Brazil, so parties will have less flexibility in relation to the terms and conditions. applicable to the platform and to the selling of products and services. And for example, Consumer Defense Code imposes that, you know, the offer shall be presented in Portuguese. We have a different approach as compared to Europe in relation to what can be considered an offer coming from abroad. If, for example, I include in my website that I can deliver a product to Brazil and I'm located abroad, then that would easily be considered an offer within the Brazilian territory, and it should be also be subject to Brazilian applicable laws. So in a nutshell, there is no specific regulation that applies to the one that wants to develop a platform, but this is a very important matter to understand to what extent the Brazilian law will be applicable, and this is mainly related to the fact that would that be considered a B2B or a B2C kind of relationship?
Thank you, Paulo. Now I'd like to turn it over to Jan and go back to the point we were at the beginning when you were speaking about the requirements to set up an online platform in Germany. Now let's assume we did it. Okay, so we have an online platform in Germany. We're operating. Can we use it to sell all over the place in Europe? Or do we need to have licenses or other requirements for each country individually?
No, absolutely. You can sell all over Europe from one online shop. This is one of the great advantages of the EU internal market, and it's used very extensively, and the European Commission is very keen to have an open pan-European market for online businesses. So let me just highlight two things which are quite important from my point of view. National regulation with regard to online purchases are more and more converging in Europe. We have European law acts which already go for a wide harmonization of the different national laws, and this harmonization will become even more coherent in the next few years. Recently, European legal acts entered into force which set out further requirements to have a harmonized national or European framework, which is reflected in all the national laws applicable within the EU. So this is one thing. We have a wide-ranging harmonization, which makes it very easy to sell from one country to the other country. And the second thing is, I want to highlight, it is not strictly required to have a German entity. The entity could be, of course, based anywhere in Europe. It could also be based outside of Europe, but having an entity based in Europe as a provider of the online business has advantages when it comes to choice of law, to taxation. And so if you are thinking about opening an online store in Europe, you should very much also think about having an entity which is operating in Europe and which will handle the online business for European customers.
So thanks a lot, and I want to encourage you all, the whole audience, to give us questions via the chat function. We will deal with that, and you are all invited to do so. I think it's a very interesting international question, how to structure your presence, the local presence of your online platform, where the servers and the computers are located, where the presence should be. Yeah, in Europe, you see that, you know, in the EC it is all pretty much the same, and there's a huge amount of harmonization also coming up. But what about Brazil? Lisa, is it now better to, if I look at that, to sell from a local presence or from abroad into Brazil? What would be your approach from a legal point of view?
Yeah, so from a Brazilian perspective, I think that it's really important for us to take into consideration that in order for you to operate with the Brazilian market, from abroad, this Brazilian market has to have international credit cards. And this isn't a reality for a big part of the Brazilian population. So what we see is that from a capillarity perspective, so in order for you to actually be able to access the Brazilian population, it's really important to be doing your business locally and setting up local presence, because through the local presence, then you'll be able to actually provide different payment types to the Brazilian market. I think that other important points here are that from a tax perspective, the highest tax burden we have is the provision of services from a foreign party to a Brazilian party. So that actually has something of a 40% tax burden on it. And so that is kind of a very significant amount, and that tends to turn customers away from contracting with foreign entities, especially if we're talking about B2B. So under the business digitalization scenario, if we're talking about contracting with legal entities rather than individuals, then we have this problem being even more clear, because of course, legal entities are subject to a significantly higher risk of questioning by the tax authorities. And I think that the last point is a point that was already made here with regard to the regulated market, and this being also a point of attention in Germany as well. But the point here is that in Brazil, we have also several industries that have a specific regulation, such as pharmaceuticals. And if you're operating from abroad through a foreign platform, you might not be compliant with all of the local regulations. So in other words, I think that from a legal perspective, but also from a market perspective, it's really important for you to have local presence in order to develop the Brazilian market.
Thank you, Lisa. Now we're going back to Europe, and I have a question for Stefan, which relates to antitrust. And we talked about setting up a platform in Europe, and we know that there are lots of changes on the competition law front. So what needs to be taken into account today and going forward in that space to be compliant with antitrust laws?
Well, yes. Well, apart from the regulatory initiatives I've already mentioned before, if you have a look at the cases from the EU Commission and from the Federal Cartel Office, most of the cases picked up concerned the abuse of a dominant market position. For example, the Google case, the Google shopping case, the investigation against Amazon, which was initiated in 2018, or also the investigation against Apple, which was I think only on Tuesday that it was announced from the European Commission. But of course, in most cases, market power will not be an issue when a new platform is introduced to the market, but still those aspects have to be kept in mind. And a lot of these cases are in particular about the aspect of self-preferencing of those platforms and hindering by that way other market participants. But what we also see increasingly in our practice is that often competitors are trying to cooperate in order to establish a new platform, or that a marketplace or a platform that is founded by a specific company shall also be used as a marketplace for selling competing products. I mean the products from competing companies. So in those cases, the platform has a kind of double role. As on the one hand side being the intermediary, on the other hand side being also active as a competitor to the other business users using the platform. For example, Amazon is probably the most known example for such a double role of a platform. And since there are no specific block exemptions or no specific rules until now for digital corporations that general competition law rules still apply, which means in the case of EU antitrust law in particular, the horizontal guidelines of the Commission. And in that respect, you should keep in mind in particular the aspect of information exchange and the aspect of price transparency. I can give you an example from Germany, where the Federal Cartel Office in February 2020 issued a press release where they stated that it had no objections against the launch of an online agricultural trading platform. And in this press release, the president of the Federal Cartel Office stated the following: in assessing online trading platforms, we focus on a number of key issues. Such networks should not result in price-fixing agreements, they should be non-discriminatory, and they should not create an excess of transparency. Particular focus is thus always placed on the type and extent of information exchange, the creation of Chinese walls between the platform users, the publication of market statistics, and the disclosure of the identity of the trading partners. So what are the questions you should consider? In my opinion, at least you should consider who will be the business users using your platform, what is the competitive relationship between you and those business users, or between the business users amongst them, and how can you structure your platform in order to safeguard that it does not lead to a coordination or the exchange of competitively sensitive information.
That's really a very, very important insight now, because the platforms are, they're all looking very suspicious on that because of the network effects and of this principle of the winner takes it all. Yeah? But maybe then the winner, the platform, is also then responsible for all. And now we are coming to the area of liability and responsibility of the platform operator. The platform operator is normally not identical to the manufacturer or to the normal seller of such goods, but it's just, another marketing or selling channel. And now, Paulo, if I go now a little bit more into the details, for defective products, we have a defective product which is sold by a platform. And how is the situation in Brazil? Is then the platform liable for defective products, for damages that were caused by such defective products? This is one part of the question. Second part, is there then any way to limit that, maybe by terms and conditions of the platform operator?
So I think the answer will depend on the business model that we are talking about for a company that wants to digitalize its business. That's because if we are talking about a B2B, in the sense that a consumer defense code is not applicable, then we would need to trust on the terms and conditions as two business entities would execute, even as compared to an offline type of transaction, where a company that wants to buy a product is free to do that and will negotiate if at all possible with the supplier, but is completely aware of the risks that are involved in buying that product. And then the terms and conditions or the contract itself should set up the limitation of liability and other related aspects involving the good functioning of the product. But I think that the complexity comes when we talk about a company that sells to consumers, where we have a consumer protection rule enforceable. And that may be the case if a company wants to have a platform to sell it directly its products and services, but also when we talk about marketplace or digital marketplaces. When we talk about the direct sale by a company that has digitalized its activity, our rule is very rigid in terms of strict liability, in the sense that the company is responsible to replace, to refund the product that is defective. But when it comes to marketplace, I mean the entity that has a platform that works as an intermediary of a transaction between a consumer and a supplier, then it's interesting because it's not something that is clearly regulated in Brazil, and we trust a lot in cases that were judged in court situations, in court cases. In the sense that, and this is what we see that is being developed, that the platform will have more liability to the extent it's more involved in the transaction. So in one extreme, for example, if we get a platform that is just an intermediation as a search engine, that is just putting into contact because it was, you know, a result of a search that was executed by an interested party, but does not, is not involved in any sense in the transaction, then it would probably not be responsible for any situation involving a defective product. But to the other extreme, if the platform provides methods of payment, if it provides the delivery of the products, if sometimes it's hard to see a difference between the platform and the supplier, then the trend is that that platform will be considered as liable as the supplier and the manufacturer. And the limitation of liability in these situations are hard to see, because the law forbids the company that is liable to avoid or to limit its liability in relation to the consumer. So it will depend on the business model that the company wants to develop in Brazil. It brings different situations involving liability.
Thanks, Paulo. I think we should go back to Europe, and in particular Germany, and essentially ask the same question. So Jan, are the rules as strict as they are in Brazil when it comes to defective products?
Well, yes and no. In Germany, defective products are part of your contractual liability towards your customers, and you are, as a platform, if you sell it directly, obliged to repair or refund the customer in case of defective products. If you're just an intermediary who is acting like a marketplace, the situation is a little bit different. It very much depends on how much you're involved. If you are actually party, like a seller, or if you're just like an agent enabling a transaction between two other parties, very much depends on this distinction. So if you are selling directly to consumers, to customers, or to businesses, you are, of course, liable for defective products. If you are just an agent, your liability is likely very limited. One thing I want to point out for the Brazilian audience in this context, there is no concept of punitive damages in Germany. So this basically takes a lot of liability risks off the table. The liability is very much awarded based on the actual damages, and punitive aspects are not taken into account as they are, for example, in the United States of America. So this puts a lot of liability risk off the table, and only weeks ago the Supreme Court explicitly reminded us that punitive damages are foreign to the German legal concept. Having said that, I want to point out there's one aspect of contractual relationship between the platform and its users, its customers. There are two other important aspects. One is a platform or an online shop can be held liable by competitors or by consumer rights organizations if there are unfair trade acts. For example, if you use terms and conditions which are not allowable, admissible, a consumer rights organization can claim for a cease and desist action on your part. So again, we do not have damages in that sense. We only have like a cease and desist action. And, nevertheless, in that case, you incur the other party's lawyer's cost. And you can also take this risk off the table to a very large extent if you have your terms and conditions checked and if you have your website checked by legal experts. So I guess this is also a liability aspect which can be limited very much. The third aspect is if you are acting as a platform, for example, as a marketplace or as an auction platform, it might occur that third parties, that sellers on your platform use trademarks or use copyrighted material without being allowed to do so. So in this case, for this aspect, we have jurisdiction and a huge body of case law to which extent a platform can be held liable in these circumstances. To cut it short, in general, the platforms must act if they are notified that there are trademark or copyright infringements happening on their platform, and then they must act swiftly. However, also in general, platforms are not obliged to check each individual offer which is made on the platform. They have to check suspicious categories, for example, by using filter algorithms. If trademark infringements happened in the past, then they also have to take care that these trademark infringements, these known trademark infringements, don't happen in the future. But you are currently not obliged to scan every single offer if there might be a trademark or copyright or other third-party right infringement. This is in flux, though, this legislation. The European Commission published an unofficial paper last year where they talked about potentially extending upload filters as they are prescribed or mandated by the recent copyright directive to other areas. But this is in a very early stage of discussion. So this doesn't reflect the current legal situation. This might happen or it might not happen. It's just in discussion. So these are the three key aspects of platform liability in Germany and to a similar extent in other European countries.
Yeah, thank you, Jan. And I think that is maybe also very interesting for the audience that, you know, in Germany and Europe, we have this terms and conditions law, which is quite severe, and you have to really look at each clause, if this clause is valid, if you can use it towards a customer. But, and this is the trick with it, you have also be aware that the terms and conditions law will also be applicable in a certain extent, and this certain extent is very broad, by the way, in B2B environment. So even in B2B environment where you do not expect it because there are two businessmen do a deal, if you put forward terms and conditions which are under German law not okay, then even in B2B context, that might be looked upon as invalid, and that might be a thing that you will get in trouble with by competitors or special associations then going after you. So this is very important if you are focusing on online and shopping e-commerce in Europe and especially in Germany. So yeah, but there are so many different types of monetization. Lisa, we have advertising, we have software development, we have intermediation of selling goods, we have the selling good of the platform by itself. So there are so many different business models. Sometimes the business models are used all on the same platform. So is there any difference in the regulation under Brazilian law for these different type of businesses?
Yes, so basically, as you mentioned, there are several ways of structuring your activities, right? So you can do ad sales, intermediation, or different activities when we're talking about business digitalization, and each one entails different consequences. So with regard to civil responsibilities, and even with regard to the tax system, so it is in fact different depending on the model that you decide to go through with. And that's definitely one of the points of attention in the sense of when structuring your activity in Brazil, your terms and conditions and your contractual aspects have to be all aligned with your specific tax structure. So we have seen the authorities actually searching the web and using factual circumstances to demonstrate that maybe the structure that the company is alleging is not really what is in fact put in place. So back to your question, it is in fact different. The responsibility deriving from different structures can be different, and it's really important to be aligned with what is foreseen statutorily. So,
thank you so much, Lisa. Now, I wanted to turn it over to Stefan, and we've covered some of the competition issues already in place, including the future of competition law in Europe. Now, I wanted to also discuss a little bit the changes underway in Germany, and if you could speak to those, and what is it that the legislation, how is the legislation going to look like if the changes currently being discussed are implemented?
Sure. Well, perhaps most of you are aware that we in Germany have a quite active cartel office. The Federal Cartel Office was already in the last years picking up cases regarding the digital economy. For example, the Amazon case regarding the terms and conditions of Amazon in Germany, and probably even more notorious, the Facebook case regarding violation of the GDPR by Facebook. And I think that the new draft of for the 10th amendment of the German competition law will provide the Federal Cartel Office, if it is passed as it is now, with even more tools to enforce competition law vis-a-vis platforms and digital businesses. Well, I just want to give the most important examples regarding the context of platform regulation. First of all, the concept of intermediation power will be included, or should be included, into the competition law. This should make it easier for the Federal Cartel Office to assess that a platform actually has a market dominant position by being able to take into account the intermediation power, in particular if a platform is a gatekeeper for specific markets. Another aspect which will be new in Germany and might be picked up elsewhere is the concept of regulation of tipping markets. There's one provision in the draft which would give the Federal Cartel Office the possibility to become active even where a company is not yet market dominant, but has what is called in Germany superior market power, which is below the level of market dominance. And particularly in cases referring to markets which have a network effects, the new provision should give the Federal Cartel Office the power to intervene in such markets when they fear that the markets could tip towards market domination if a company is not using competition of the merits, but trying to hinder other platforms to create their own positive network effects. So this is a provision which should which tries to avoid the tipping of markets, which is quite a new concept in our competition law. And another aspect which is highly debated at the moment is a new competence for the Federal Cartel Office regarding companies with paramount cross-market relevance for competition. So this is some kind of supermarket power. So this really is a provision which addresses the really big players. What is interesting about it, the Federal Cartel Office can first has to establish that a specific company has this kind of supermarket power, and once it has established this, then there are specific rules which the FCO can say are not longer okay. For example, self-preferencing, the leveraging of market power, for example, to the use of data from one market in another market, the hindrance of interoperability or the portability of data. And interesting about this is that the Federal Cartel Office can prohibit such practices unless they are justified, but the companies then have to prove that they are indeed not anti-competitive and justified. So this new rules, this new laws, if they really will be passed like they are at the moment in the draft, will certainly give the Federal Cartel Office new tools in order to be even more active in the field of enforcing competition law towards platforms.
Thank you very much, Stefan, on the competition issues, which are quite important if you enter the German market or the EC market. And I'm very interested in the liability situation again, because, you know, here in Europe, when you wanted to buy a cheap Rolex watch, what do? Then normally in former times, in your holidays, you went to the beach, and then you spotted some traders who had very beautiful Rolex watches at a very good price. I don't know if it is perfect. You know, you get Rolex watches on the beach in your holiday. They are perfect. They're beautiful. Everything is fine. But after the holiday, such Rolex watch does not work. I don't know if you have the same in Brazil. You have also lots of beaches. Maybe you have also this. And now, but this whole market now vanished. If you want to buy a fake Rolex, you don't have to go to the beach any longer, but you can look at some platforms, and that was a huge debate and also a huge row of court rulings then about Rolex. Rolex always was against these counterfeiting Rolex watches, which were then sold via platforms. And as Jan already pointed out, there was, a quite back and forth, is the platform liable for those fake Rolex if the fake Rolex was not, put in by the platform operator, or is it not liable? And then you say, no, you are not liable, but you have to, if you know that there are, then you have to observe that, and you have to take down, and if you don't take down it, then you are liable for that. So there was a really complicated row of court decisions, which is even not at the end. And now I'm very interested because you have so a huge area of beaches. I think the longest beaches of all countries over the world in Brazil. So how is that working in Brazil with the fake Rolex watches, and how are especially platform providers suffering or not suffering from such a change from the beach to the platform of such Rolex watches selling?
Oh, Peter, I'll tell you that nobody in Brazil will go to the beach looking for a Rolex. They look for very different things. but there are many places to buy the counterfeited products in Brazil. So it's not a problem to wear, but you can find them. And as you mentioned, this is something that was transferred to online platforms discussion as well. And in Brazil, we have been discussing this for a long time. This was something that initiated with court discussions, and it reached the superior courts. But in 2014, we have enacted a law aiming to broadly regulate internet, and there's a specific provision there in the sense that platforms should not be liable. And I think this is something that is very general throughout many different countries. The platform should not be liable in relation to the content included in a platform by third parties. I mean, it's not the platform that is the one to control content, the one to impose censorship in what people share within social networks, or even in other platforms where people can express their ideas. In addition to that, the courts have been understanding that even for transaction activities such as selling goods and services, the platform has the same type of immunity in the sense that we are not talking about expression of ideas, but the idea that a platform is not the one to control content, not impose censorship, even for selling products and goods, then the platform should not be held liable. But the provision says that if you want to take down a certain content that is infringing a trademark, for example, then you need to have a court order, and then the platform needs to follow that court order, otherwise it will be considered liable as well. What we have as an exception to this is that law says that when it comes to authorship rights or copyrights, so not related to trademarks that we see in a product like you mentioned, but if it is a song, if it is an audiovisual product, then it's not necessary to have a court order. So it works much more like a notice and takedown system for the platform not being held liable. So that depends a lot. There's a lot of debate. There's a lot of things going on. This specific section is being under analysis of our Supreme Court, if that is constitutional or not. So it's a very hot debate in Brazil. But it's something that is being the trend in the past years, and I of course it's my time to get back to the moderators. But we saw Stefan talking a lot about competition issues in Europe, and we have Amadeu in our firm that is much dedicated to this matter. If he could, clarify what is the scenario in Brazil involving business digitalization and antitrust in Brazil, that would be interesting to hear as well.
Thank you, Paulo. So as the moderator, I get a chance to answer one question, which is great. And to wrap up our webinar, because we're coming close to an end. So I think that Brazil is different than Europe in two main respects as far as competition law is concerned. One, we have one law that is not subject to change at the moment. In other words, we do not have the same debate we have both in Europe at the European level, the EC level, and the German level about changes in competition laws to address specific issues of the digital economy. There's no such thing. There's one antitrust law, and then there's the experience with that law, which leads me to my second point. The second point being we have a limited number of cases. We do not have an enforcement that is as strong as it is in Europe. We do have a few cases touching on some of the issues that Stefan in particular covered. And I'll talk about self-preferencing, for example, and data-related cases. And you've alluded to a couple of cases under those subjects in Europe and Germany, Stefan. And so in self-preferencing, I think that the most prominent case certainly is Google Shopping. And there, Brazil dismissed the case. The ultimate result was in favor of Google, and Brazil didn't find evidence that the company engaged in practice that would rise to the level of an antitrust violation. But then, if you look for more general guidance on self-preferencing, I think that's still being developed, and we may see more cases down the road offering, I think, more clear guidance in that respect. And then with data-related cases, meaning the intersection between data privacy and antitrust, we have no such thing as the Facebook case in Germany, for example. There is absolutely nothing out there that would even come close to that. Data privacy is an important subject in Brazil, but it's mostly dealt with under a separate law, data privacy law, and not perceived as an issue that should be in the hands of antitrust enforcers. I will say, though, that there are a few cases out there where CADE, the antitrust authority, has looked at data as an important input to competition. And has alluded to the fact that online platforms in possession of substantial data sets would have in the possession of those data sets a significant competitive advantage. But those comments were made sort of in passing in a few cases, and they were treated pretty much the same way that Brazilian authorities would treat other key inputs for competition in other markets, right? So not justifying a special treatment in any way. And so I think we're still seeing the law being developed in Brazil, but I think we're a little different, not to say very different than Europe and Germany in that respect. With that, I wanted to then conclude a webinar. Thank you very much, and say a big thank you to the speakers, and a big thank you to Noerr for joining us today. It's a great opportunity for two firms to collaborate, and I think hopefully we provided the audience with helpful insights. We touched on a number of topics, not just competition, of course, but overall, I think if you were to have a main takeaway from this webinar is really to have, I think, a checklist of the things you need to pay attention to when setting up an online platform. Competition law is obviously an important aspect, but other aspects that we discussed are equally important and sometimes more important, depending on where you are in the stage of your business. Product liability, regulatory aspects, terms and conditions, I think, are important elements, especially in Europe, tax and data protection. And so thank you very much, and we will adjourn. Thank you.
Bye-bye.